Is the Holmes versus Marion County case. Holmes versus Marion County. Are there any other parties on Holmes versus Marion County? Come forward, please. All right, gentlemen, you may begin.
May it please the court, my name is Craig Willis with the law firm of Fixel, McGuire and Willis. We are representing the appellants in this case, William and Judith Holmes. This is an appeal from an adverse trial court determination of an inordinate burden upon real property under the Burt J. Harris Jr. Real Property Act. This involved the operation of a construction and demolition debris landfill in Marion County. Mr. and Mrs. Holmes operated a landfill on their property from 1983 up until the closure of the landfill in 2000. The landfill from 1993 to 1998, 1999 was permitted by the Florida Department of Environmental Protection.
It was a temporary permit, although it was over an extended period of time. But there was a time when it was going to expire, right?
Yeah, the county's operating special use exception to their land code. The DEP permit was renewed in 1998 for a 5-year period of time to run until August of 2003.
For a specific period of time, at which time it was going to automatically expire. And isn't that right?
The county special use exception ran until expired in May of 2000. And in 1999, they reapplied for the special use exception under the county code, and it was a special exception to the zoning category. The special use exception.
And that was denied.
That was denied. That was
so if we have a permit that expired for a certain period of time, temporary permit that expires on a specific date or at a specific time, and then it's up for renewal and it's not renewed, I'm having a difficult time understanding how the Act even applies in the first place.
This is an existing use on the property that has.
Let me ask you this: why can't an and I think this is the point Judge Swy's making, why can't an existing use be a temporary or time-limited use? In other words, as I understand your position, it's since the appellants were allowed to use this property as a landfill on the date that Burt J. Harris came into effect, then forevermore this is a use that has to be allowed, or unless and if it's denied, then compensation's owed under the Act. But why can't the existing use be a temporary use? In other words, if the county said, well, I know that we've authorized this use until whatever date, but we're gonna amend the ordinance and change that. Now it seems like you have an argument, but to me, it seems like an existing use can be for a fixed or limited period of time, and that seems like the circumstance here.
The special use exception is much like an occupational permit or an occupational license. It has certain standards under the county code. However, the Burt J. Harris Act specifically provides statutory standards for the types of uses and types of remedies it provides. This is not an inverse condemnation claim in which you're saying you have a vested right to use something from time immemorial. The Burt J. Harris applies to a type of government.
But it applies to either an existing use or a vested right. And you agree that this is an vested right to get permit renewed. Yeah.
Absolutely,
Okay.
the county,
So, but you're saying
has the
that
authority to do this.
you're saying that because the temporary special use permit was in existence at the time that Burt J. Harris came into effect, even though you agree it's not a vested right, it becomes an existing use that therefore does, under your theory, have to be renewed, or the county has to renew it forever, or pay you.
Well, it would be forever. There's a limited amount of airspace.
That's not why this act was enacted. That's not the purpose of this act. I mean, you had a permit or authorization to use property for a specific period of time after which it expired, and you're going to have to reapply. And you're saying that if that's the case and you reapply, that there is no alternative under this act but to continue that use. That's not the point.
Absolutely not. Absolutely not. There's an exception for a nuisance use, for obnoxious use of property. The county didn't take that road. They did not take that procedure. The existing use, just like you have any type of other type of use, whether it be a residential.
Let's say it's not noxious and it's not, it doesn't meet that exception. Then what you're saying is that every time that there is a temporary permit that allows you to use the property for that period of time only, that it has to be renewed under the act.
Well, when you say it has to be renewed under the Act, I don't think it has to be renewed. I don't think there's any requirement to be renewed. But Burt J. Harris gives property owners relief when there's an inordinate burden placed upon them by a political decision by the county.
Say that your client went to the county and got a special use permit to have a big music festival on his or her property for a week. It's Woodstock in Florida. And that just happened to coincide with the effective date of the Burt J. Harris Act. And so under your theory now, if the county doesn't allow that to continue forever, to just renew that period week after week so that now this is a permanent music festival, they're going to have to pay you compensation because they've just burdened an existing use. Even though it was a week-long permit, it just happened to coincide with the time that the Harris Act was enacted. I mean, that's basically what you're arguing in a different context, isn't it?
I think a better example is a flea market that's operating on the site. It's a continual use. It is existing use, a music concert. I guess you could make the argument extending it further that
it can't be a continual use because it's authorized for use for a specific period of time after which it expires. And then it's got to be renewed.
Unless there's a request for it to be renewed, just like any other occupational permit or use has to be.
You requested that there be a renewal, and it was denied.
That's correct, and that was the governmental action.
But for an occupational permit, you don't have to go in and show that it's consistent with existing uses, that it's consistent with the comp plan, and make the kind of showing that you had to make and failed to make in order to get a renewal of the permit.
Under the Burt Harris Act, there's a dichotomy between an existing use and a reasonably foreseeable future use, a contemplated use into the future. And that standard that you're talking about under the Burt J. Harris is addressed that it has to be suitable and compatible with adjacent land uses. That's a future, foreseeable potential use of the property, not an existing use. And the county denied it under the basis that it was not suitable, even though their county staff concluded that it was suitable.
Aren't we bound by that finding? You lost that issue. Is it even relevant what county staff said in the recommendation before the board made its finding?
I think it is, because I think it goes to the fact that the county in their brief said that the denial was in part based upon it was found to be a nuisance. And if it had been found to be a nuisance, there is an exception under the Burt J. Harris Act, in all candor, that would not have allowed a Burt J. Harris Act remedy to prevail.
But my question is, aren't we bound by the administrative or quasi-judicial finding of the county that the issuance of the special use permit for an additional period of time would be inconsistent with the land use plan, inconsistent with surrounding property? I mean, that was the finding. You challenged it on appeal, and the cert appeal, you lost that, so you really can't.
I think it has to be on the basis that they found it, that for whatever weight it's worth, the administrative finding, it says it is not compatible with surrounding land uses and is not consistent with the comprehensive plan. But that's not a standard that doesn't allow a property owner to be entitled to relief under the Burt Harris Act for an inordinate burden. That's a political decision that the county makes that has imposed a financial burden of over $1 million on my client that should be borne by the county as a large. If the county decides in the middle of an existing use before the airspace is used up that they don't want a landfill there, fine. They have the power to do that. But the Burt J. Harris gives a property owner an entitlement to be compensated for that burden that should be spread around for everybody.
Let's talk about the county. Who was Mr. Ward and
Mr. Ward,
resolving the economic burden and how you read it?
Mr. Ward was an MAI, Florida licensed appraiser.
Had he done landfills before?
He had not appraised a landfill per se. He had appraised special use properties. He had appraised all kinds of various.
In this evaluation, since he had not done landfills before, did he look at other landfills and this one to get a dollar value of the damages?
He talked to other appraisers that had.
Well, my question was, had he looked at and reviewed other landfills and this one before reaching a conclusion?
I don't recall that he had before and after comps of landfills. I do recall that he followed the MAI standards for appraisal of landfills and special use properties, and he consulted with other appraisers. The judge denied his testimony on the basis that, number one, he hadn't performed a landfill appraisal before, which that's a standard I've never heard of before, and secondly, that he made an assumption. And the assumption was a typical assumption that appraisers make in condemnation, eminent domain cases all the time. What is the property worth if the permit was allowed to run to August of 2003, and what was the landfill worth if it had to close in May of 2000 with the denial of the special use exception by the county? So
was it the judge's discretion whether or not to allow an expert to testify?
The judge has a discretion. However, number one, it can't be abused, and this is a clear abuse of discretion in this case, because not allowing testimony because somebody hasn't appraised a specific type of property for is improper. But however, even if you throw out Mr. Ward's testimony entirely, we had clear and convincing evidence that there was an inordinate burden.
And the managers?
We had a contract, a purchase for sale. The difference between what they would pay for it if the special use was granted and what Mr. Holmes ultimately ended up paying for it. There's no better evidence than that. That was a before and after that the Delta Resources manager for the Delta Resources came in and testified that the only thing that was holding up this contract was the renewal of the special use exception in this case.
Judge Lawson mentioned the legislative act of the county government. To me, the bill is about protecting the economic interests of private landowners from overburdening government. In this case, there was a finite period of time that the government said you can make money using this piece of ground as a landfill. Is it your argument that they can't stop you from working, and if they do, they've got to pay you monies, and that's it in a nutshell?
It is in a nutshell, but I think you have to look at the context. If you're saying, well, I don't like the legislative act, I mean, this is the language in this act is clear.
Well, let me ask you, just so I understand the parameters of your argument. This special use permit was in effect when the Burt J. Harris Act became law, correct?
That's correct.
Okay. What if today, different piece of property, different landowner goes to the county and says, we want a 5-year special use permit to operate a landfill? So it wasn't an existing use at the time Burt Harris came into effect. But if the county grants that, would it be your theory that if the landowner came in 5 years later after the expiration of that permit and was unable to show that the continued use as a landfill was consistent with the comp plan, so that the permit was reasonably denied, would the county still owe money to the property owner under that?
I don't think so, because of the definition of existing use in the Burke J. Harris Act. I mean, the statute is clear on its face.
So if you have let's get back to your example of a flea market, and a flea market is given a special use permit for, let's say, 2 months, and then it expires. And you go back in and you reapply for the permit, and they don't give it to you, and you allow damages under the act.
Depends on when the flea market, using Judge Lawson's example.
Let's assume that the act is in effect, and they grant you a 2-month special use permit. You can use the property for a flea market for 2 months, and then you have to come in and reapply. And it expires in 2 months. And it expires, you go in, you reapply, and say, no, we're not going to renew it this time.
On what basis? Just don't want to do
Well,
it?
let's say the neighbors come in and say that we object, we don't like the traffic, and we just don't want it here anymore. And they say, okay, well, that's a sufficient reason.
The statute says that when a property owner is permanently unable to attain the reasonable investment-backed expectation for the existing use of real property or vested right to specific use.
Because that was only for 2 months. I mean, he has an expectation and a reasonable right to use it for 2 months, and that's it. Then it expires. After that, he got no expectation at all, unless it's renewed.
If it's compatible with the zoning, and it's not a nuisance, I think a county under the Burke Harris Act, a local government has the right to look at it.
Why?
If it's a nuisance to the community.
Wouldn't that be a disincentive for them to grant these special use permits on a temporary basis, period? Because they know that if that's the case and it's not renewed, they're going to get hit with a suit under the act.
I don't think it's a problem today because of the way the Burke J. Harris Act is written. The Burke J. Harris Act created a right for existing uses as of 1995. And
Why does that make sense from a public policy standpoint that the legislature would have just sort of arbitrarily given this bonanza to anybody who happened to have a temporary use permit for land that was in effect at the time that this act became law? I mean,
anytime you bestow a remedy or a right, there's going to be some people that are going to receive the benefits of it, and there's some people that are not going to be able to recognize or be able to receive the benefits. And I don't see it as a bonanza. This man had a legitimate, lawful business that the DEP was in good standing. They had invested. This is not like the Best Diversified case in which DEP had determined that the landfill was a nuisance. They had a good operating permit with DEP. They had addressed the problems, and DEP said that your permit's in good order. DEP is responsible for the operational permit for these types of landfills. And the county merely made a political decision to deny this man his right to complete.
His right expired after the special use permit expired. It ended, didn't it?
The lawful right did, but he has a remedy under Burke Harris for compensation for that, is my whole point.
Okay.
You've got 3 minutes, 3.5 minutes remaining, sir.
Thank you.
Good morning. May it please the court, my name is Thomas McNamara. I'm Chief Assistant County Attorney for Marion County. I also have with me Michael May, who is the Bureau Chief for the Zoning, Building, and Planning Department. And I have been blessed to be with Marion County throughout this particular special use permit saga, which in effect began in 1993. Prior to the adoption of the Burke Harris Act. And I think that's a key decision because the Burke Harris Act actually addresses pre-existing uses. It also addresses temporary uses. And in this case, the facts are clear that this was a temporary pre-existing use.
Where does it address temporary uses?
I'm sorry.
Where in the statute does it address temporary uses?
I'm going to have just a moment. I believe it's section 70.0016E.
Okay.
And the statute says that when you have an existing use and there is a decision made regarding that decision use, Bert Harris just applies to that decision. And I'm paraphrasing the statute. Statute isn't the most clearly worded statute, but we have to go with what the legislature...
Your interpretation of the statute is if you have a special use permit for a specific period of time, then it expires, if the act doesn't apply?
It only applies if there is an additional right granted beyond that use.
So let's assume that you have a special use permit for a period of 5 years.
Yes, sir.
Then we know it expires, unless you come in and try and renew it.
Yes, sir.
All right. It expires. You come in and you try and renew it, and they say no. The expiration period has come and gone. Does the act apply?
The act applies only to the renewal decision, if the decision were to be granted an extension under the statute, under my...
Well, let's assume that the decision is we're not going to renew the special use permit, you're over and done with.
It does not apply in that circumstance. And
Okay,
that's...
so let me just real quickly, there is no 6E in 70.001, at least in the current version of the statute. You want to just paraphrase or give me some way I can find the provision that you're talking about that deals with expressly with temporary uses, because I don't remember seeing a provision that dealt expressly with temporary use.
My apology, Your Honor. Let me see if I can get you a correct reference. My apologies, I do not have that. It is cited in the brief, though.
Tell us what it says
Here.
about temporary uses.
That the Burt Harris Act would only apply to the subsequent decision. If the subsequent decision were to grant the permit for an additional 5 years, it wouldn't apply to the existing term. And that's critical in this case for two reasons. The first reason is that their appraiser came in and didn't know he hadn't reviewed the special use permit with the limited term. The second reason is that the appraiser came in and said that when the Board of County Commissioners agreed to deny the special use permit in 2000, that
Well, that would have been the renewal, right?
to deny the renewal, at that point, the property lost all its value, even though it had an extended period under the existing special use permit. The limited time period had not run. And that is critical here because that was a deviation from the facts, the clear facts. And Chapter 90 Florida statute says an expert opinion has to be beneficial to the trial court based on the facts that are currently before the court. The county, in the denial of the extension of the special use permit, had the advantage of the circuit court reviewing that under a petition for writ of certiorari. And under the county code, the applicant for a special use permit has a burden, which he must show. He must show consistency with the plan, compatibility with surrounding property, and no adverse effect to the public. And he could not show that, primarily because the C&D material included wallboard, which was creating an odor. And council has relied on the fact that there was no nuisance and there was no code enforcement action by the county. But considering that the permit was going to expire by its very terms, even a code enforcement action would have taken longer than the permit would have expired. And the county's decision was it was a temporary use, it was going to expire, it did expire. Now, his request to extend it was reviewed by the circuit court, and the circuit court denied certiorari. So we had a judicial review of that situation also. And Your Honor, I apologize for not having the valid cite on that, and I'll make sure I get that to the court.
I looked at your brief and I don't see it quoted in there. If you're going to start an argument by saying that the statute expressly addresses something that would be critical to the case, you might want to bring that to our attention pretty prominently.
Yes, sir. And again, my apologies. They could not demonstrate that the continued use of this landfill was compatible with surrounding property owners. And the appraisal was based on speculation that this use would continue beyond its fixed term. Now, under the speculation portion of it, it has to be compatible with surrounding properties. And
Let me ask you this. Let's assume that the 5-year period expires, they come in, they apply for renewal, and the county says, we're just not going to renew it, period. They don't give any explanation or reasons why. The county says it's expired, it was temporary for 5 years, and we're just not going to renew it. And then they try and bring an action under the Act. Would the Act apply?
I do not believe, as it's currently written, that the Act would apply. I think it's clearly a temporary use of property. You have a right to use within the period of time set, and the original thinking back in 1993 was that this was a mining site, and it made sense to fill up the mined portion of the site with inert material. And construction and demolition debris is supposed to be inert material, concrete, metal, non-protrusible, which is your Class 3 landfill. There shouldn't have been the odor that was present in this particular one, and they identified where the odor was coming from. It was coming from Palm Beach County. It was coming from out of the county because they didn't want to smell it in South Florida. They would rather move it to North Florida. And the surrounding property owners made numerous complaints to DEP. The record supports 5 separate trips.
Well, if the county, in denying the permit, had made an express finding that the landfill was a nuisance because of odor, and then that had been affirmed on cert review, or there had been no relief on cert because it was based on competent substantial evidence in the record before the board, then I don't think we would be here because there is an exception for nuisance. But on the record that we have, there was no finding of nuisance, so I don't understand why that's an issue. Because there was no finding of nuisance by the board, so it wouldn't appear to me that the nuisance exception would apply under these circumstances. We can't speculate that the board would have found a nuisance if asked to find one, or would not have found a nuisance. It's a disputed issue. We can't resolve that here.
I certainly agree. But the nuisance is a dual. There's nuisance and there's noxious use of property. And clearly they're not the same thing.
Well, the board didn't find either in this case, did it?
Well, they had complaints that it was a noxious use of property when they were called upon to make their decision in 2000 regarding the renewal and compatibility of the extended use. So there is evidence in the record regarding the odor and the complaints of neighbors regarding the odor on the property. So there is evidence of a noxious use of property, and that exception in the Burke-Harris Act is relevant. And that's why I bring it up.
Did the trial court make a finding that there was a noxious use?
I believe it did, yes, sir.
Where is that? You want to give me the record site for that?
Have a moment.
Would it be in the order of October 23rd?
Yes, sir.
Paragraph 12.
Thank you, Your Honor. Yes, sir. Page 9 of 10 on Appendix 1 of the initial brief. And thank you for the reference, because on the preceding page is section 70, on page 8, is section 70.001, paren 13. And if I may read that real quickly, no cause of action exists under this section as to the application of any law enacted on or before May 11, 1995, or as to the application of any rule, regulation, or ordinance adopted or formally noticed for adoption on or before that date. A subsequent amendment of any such law, rule, regulation, or ordinance gives rise to the cause of action under this section only to the extent that the application of the amendatory language imposes an inordinate burden apart from the law, regulation, ordinance being amended. And thank you. That's an assist. Appreciate it. And that's critical to this case. It was a temporary use of property. The temporary use expired without any action of the county. Now, they tried to demonstrate through their appraiser that the county's decision in 2000 terminated the existing special use permit term as of that date. And that's the fiction that the trial court would not accept. He was appraising landfill property that had a specific term, a specific expiration date, and he was not aware of that expiration date. He testified that he was not. He was not aware of the facts governing the use of the property that he was appraising. And there's an old DOT case, and I'm paraphrasing the decision, but the FDOT appraiser said, oh, he's not entitled to severance damages. He can move his excess parking over on this other area of the property. And so he's not entitled to severance damages. And the court said, you're using his property. You can't do that. That's a false assumption. And that is within the discretion of the trial court. Secondly, the basis that he had no other landfill experience. Both reasons are cited by the trial court for not accepting this expert testimony. And clearly an abuse of discretion has not been demonstrated. Clearly, the Burke-Harris Act cannot be construed to apply to extend any temporary use of property beyond the fixed term. That is clearly not the intent of the legislature. There's no language to suggest that that is the intent of the Act. And clearly, the Act is to extend the taking law from the judicial decisions of the court and, in my opinion, to make them subject to appraisal decisions of the appraisers. The last point I would like to bring to your attention is the fact that there was no bona fide valid appraisal submitted to the county in this action. There was also a difference between the estimation that was presented on cubic feet, charge per cubic feet, and what Delta Resource was actually paying at the time. Lastly, touching on Delta Resource, they were the largest customer of this landfill. They were bringing in truckloads of C&D debris from South Florida, and clearly they walked away. Their agreement to purchase this site was less than they were paying in tipping fees. Of course, they're going to make a decision where they have no liability, they have no earnest money, they don't suffer any consequences by walking away. They were speculating on the extended use of this site beyond its temporary period. And that is speculation that is not recognizable under the Burt-Harris Act. If you have any questions, I'll attempt to answer them.
Thank you, sir.
Thank you very much.
Thank you.
Are you familiar with the Osceola County case?
I beg your pardon?
Are you familiar with the Osceola County case?
I am diversified.
And in that case, they dealt with obnoxious odors and the interference with the neighbors' enjoyment of their properties because of the odors.
There was, you're talking about Best Diversified Osceola
Yes, sir.
County. In that case is distinguished from this one in a number of ways.
My question is, you're familiar with it?
Yes.
All right. In this case, there is a finding that there were obnoxious odors that interfered with the neighbors' right to enjoy their property, and that...
In this case or the Best case?
In this case, sir. The paragraph 12 of the order?
There was a statement in the judge's order that it was based in part on a finding of noxious use, but that is a conclusory comment. The judge had no evidentiary ruling, and he didn't have any role in doing that. He bases it upon the county's action. Now, the county's action is set forth in their denial for the permit.
Would the Best Diversified case support the judge's ruling and order on that issue?
Yes, it would, because, and it's also supported by this court's previous ruling in Best Diversified, because DEP went in and investigated the complaints and concluded that it was a noxious use, a nuisance, and they made that specific finding, and the property owner had a right to contest that determination by DEP, and their permit in Best Diversified was not in good standing. There were these same complaints in this case in which DEP went in and investigated those complaints and sent off lab samples. It's in the record to California. There was no evidence of the fumes, the odors, and the air samples that they took. They determined that the other complaints that were being made by the neighbors were being addressed by the property owners. These were conscientious operators of this landfill, and the DEP permit, operating permit, was in good standing.
My point is, was that a basis, or could that be a basis for the county to say we're not going to extend your permit?
Absolutely. Under the Burt-Harris Act, there was a determination of a nuisance in the Best Diversified case, and that's an exception under the Burt-Harris Act to relief being found. In this case, that was not done. There was no due process to these property owners. In fact, the process that was given to them was the DEP investigation and conclusion that there was not a nuisance, that their permit was allowed to.
Let me ask another question. In this particular case, I think before the expiration period of the special use exception came about, you applied to renew it. Is that basically right?
That's correct.
Right. What would have happened if the 5-year period had expired, and then sometime later after that, you came in and requested to have it renewed? Would the act then apply?
That's a good question. I'm not sure I know the answer. I know the answer if it's sort of like an abandonment of a use.
No,
you
just,
have
I
to go
mean, you
back
know,
in for a permit.
no, I don't know about abandonment, just forget about abandonment. I'm just saying that the time period expired, and then after that, you came in and filed an application to renew it. Would the act apply? And if you say the act doesn't apply, then, you know, how does it logically follow that would apply? It would apply simply because you made the application before the expiration period.
I don't know the answer to that question. I would say, as you seem to be troubled by that, if the DEP permit was, if it was a continual use, it was an existing use, is what your point is.
Well, the DOP or DEP permit doesn't necessarily require the county to come in and renew the special use permit. I mean, that's not the case.
No, it just gives the right for the existing use to exist.
Well,
That's what I'm saying. If you don't have an operating permit, you can't operate. They'll shut you down. You can't operate.
But under your theory, if DEP didn't extend the permit indefinitely, then you'd also have a Burt Harris Act claim against the state of Florida, correct?
It depends on the basis for the denial.
Assuming that it's not denied based on a noxious use.
Right. Well, then I think DEP would be in the thick of it too.
Thank you, sir. We're going to take